Please like, share, and subscribe. Ready? Start. This quote, while considering the aforementioned interlocutory application, had ordered that since there was no order forfeiting the performance security and since the petitioner had been informed by its banker that the same was sought to be invoked without any decision by the authority to the said effect in the impugned notice, a direction was issued to the Bank of Baroda that if the bank guarantee had not been paid to the respondent NHAI, the same would not be paid until further orders of this court stop. The NHAI has argued the matter at length and has tried to justify their action by stating that the authority had initiated action against the petitioner on the basis of a complaint dated 11/5/2012 received from Honorable Member of Parliament stating that the petitioner was using false and fraudulent balance sheet and net worth certificates for gaining the control of the toll plazas in the NHAI. Stop. The NHAI thereafter resorted to an inquiry and report was submitted by one Fortress on 11/6/2012, which related to the projects at NH2 in the state of Uttar Pradesh, NH27 in Uttar Pradesh and NH28 in the state of Uttar Pradesh. Stop. This certificate within bracket Annexure B by Fortress Infrastructure Advisory Services, addressed to the NHAI, however, does not mention anything regarding the project of Bihar, which is sought to be cancelled by the impugned letters. Referring to Annexure 8, which is the so-called notice dated 18/10/2012, Learned Counsel for the petitioner submitted that apparently the authorities have prejudged the matter in as much as they had come to a finding that the certificate dated 12/11/2011 of the CA firm, which reflected the net worth of rupees 16.15 crore for the financial year 2010-11, was a forged certificate, and therefore having submitted a false net worth certificate, they were guilty of violation of clause 2 within bracket D of section 2 of RFP, and they were called upon to so cause as to why actions for terminating the LOA and forfeiture of performance security be not taken against them. Stop. Further, the reply to the so cause was to be submitted within 10 days from the date of receipt of the notice, and they were also given an opportunity to represent their cases personally by taking prior appointment with the general manager of the authority before expiry of the said period of reply. Stop. However, close on the heels of the aforementioned notice, the authority proceeded to issue another NIT on 23/10/2012, just 5 days after the issuance of Annexure 8. Stop. This clearly indicated that the issuance of the so-called notice was but an empty formality, as the respondents had already decided to terminate the contract of the petitioner, and reply which was to be filed by the petitioner would necessarily be a futile exercise. Stop. What followed was to the apprehension of the petitioner, as the NHAI wide order dated 4/12/2012 within bracket Annexure 11 withdrew the letter of award of the petitioner with immediate effect, which came under challenge in IA number 3089 of 2013. Stop.